Hello and welcome to today's seminar. Today we're celebrating the final submission or oral presentation of Neil Sutherland. His presentation topic is epistemic landform, agriculture and water resource management to help courts determine land use conflicts. Neil is an agricultural and environmental scientist, a hydrographer, and a farmer with a small beef herd in northern New South Wales. Starting out farming in the United Kingdom and after stints working in the Middle East, much of his career has been spent consulting in Australia. He has worked in all manner of challenging environments and assisted in controversial litigations from coal mines to solar farms. Trained in the UK at Sale Hain and Silsco Agricultural Colleges in the UK and at Griffith University in Brisbane, he is regularly called upon to provide expert witness evidence. Neil established the consulting firm Gilbert and Sutherland Pty Ltd in 1997 and has served industry and community through voluntary roles as former chairman of both the Queensland Acid Sulphate Soils Committee and the Gold Coast City Council's Water Future Committee, overseeing the creation, consultation and implementation of the Gold Coast Water Future Strategy. Recognising an increasing level of complexity in land use conflicts coupled with the increasing vagaries of our climate, he assists landholders resolving conflict over landforms, agriculture and water resources where he can. He subscribes to the view of Nathaniel Kent, published in 1796, that agriculture is unquestionably the first of all sciences as it nurses and supports the rest. Before I welcome Neil, I would just like to add to those of you who are joining us online that if you have questions during the presentation, there will be questions at the end and we welcome them from you, but you're also welcome to type them in the comments and I will be reading them to Neil at the close of his presentation today. And finally, I would like to acknowledge the land upon which Neil is speaking today, the land of the Ngunnawal and Ngambri people. This land is unceded and it has held a long tradition of people presenting and sharing knowledge together in this place. This always has been and always will be Aboriginal land. Neil, welcome.
Thank you, Rosie. Thank you very much for attending today. Professor, staff, fellow students, and people watching online, I'm grateful for you attending. I'm going to cover these topics today, and as you can see from the title, this is about epistemic landform, agriculture and water resource assessment to help the courts. And this concept of helpfulness in courts is something that I'll return to throughout the presentation. We'll be looking at the issues, the thesis, the land use conflicts, and going through a methodology where I have gathered together the critical attributes and indicants to look at landform, agriculture and water issues, gather them in a visual hierarchy, and then knit them together in a usable indicant or a guide to assist principally experts, but also stakeholders in looking at the way evidence is put together. The whole objective is to save time and to save money when litigation occurs. As Rosie said, please come in. As Rosie said in the introduction, my background's in farming, and I just wanted to run you through just a couple of slides to indicate that these concepts that I'm talking about today, they don't have geographical boundaries and they don't have jurisdictional boundaries either. This is the farm that I worked on from the age of 11. And for those, it's in the south of England, and for the observant amongst you, you'll see that there's now a vineyard on there. This reflects the migration of champagne grapes out of Champagne in France and over the Channel and to other areas of the world like New Zealand. This is a farm I also worked on in the Scottish borders in the far north of England in Northumberland. The farmer on this farm is a lifelong friend, and he subscribes to the old proverb that he didn't inherit the land from his father, but it's on loan to him from his children. It's on loan to him from his children. That's a key concept, that we're being loaned the land for stewardship. This is another project that I worked on in the Middle East. This is in the southern interior desert of Oman. I was seconded in to grow fodder, Rhodes grass, and all manner of other vegetables in an agricultural project run by Shell, Royal Dutch Shell, but on behalf of the Sultan of Oman. This was to demonstrate to people in the locale, the Bedouin tribesmen, that there was benefit from the oil industry coming in. And this project used fossilized water. So there were all kinds of sustainability questions about the use of that. And this is where I'm farming now with my family. Very similar in terms of hill pasture to a lot of the problems. And the problems, if I get time at the end, I'll come back to in terms of the increasing vagaries of our climate change. So here are the issues, and it really goes to cost. It goes to time, and when matters get to litigation, the courts operate by very rigid rules, and expert witnesses have to perform by those rules, excuse me, as well. Courts seek expert evidence where they don't have the expertise themselves. So here's the tension. If the courts don't have the expertise to recognise evidence that is not based on sound data, then the risk is that it's influenced by the theatre of the presentation rather than the epistemic value of the evidence that's been gained. So the principal premise is that sound opinions require adequate data. The thesis is very straightforward. The land capability evidence requires epistemic assessment, and the idea is that a systematic indicant will help improve the efficiency of the court process, principally by dealing with these problems before they get into court. Now, just in respect of expert evidence, there is in my view, a distinction between a scientific expert and a professional witness who just repeatedly gives evidence and that's their career. I've, over the years, since 1995, given evidence in over 140 matters or prepared evidence for them, but a lot more have settled where I've been put into what's called the joint experts process, where before the lawyers get involved heavily, I'm able to meet with my counterparts and discuss the evidence and go through what the data is, where we need extra data. That is a form of high pressure peer review. It's a wonderful thing, career-wise. It's a great thing to be exposed to. And it also increases your self-awareness about what you're doing right and what you're doing wrong, because as processes change and as procedures improve, you get the benefit of it. Ideally, you come with sufficient data, but that's quite rare. That joint expert process is used in the New South Wales Land and Environment Court and in the District Court in Queensland through the Planning and Environment Court. The goal is very clear: cheap, rapid, efficient justice. It's a bold statement, but it really reflects what everybody's aiming for. In the Queensland Planning and Environment Court, the judges are in the District Court as well. That means hold-ups in the Planning and Environment Court can have knock-on effects to people being held on remand, and they can be, a comment's been made that they could be kept on remand for longer than the sentence that's handed down to them. So it's completely unfair if court time is wasted. I'm just going to give you an agricultural view, and it is, I'm not a lawyer, but the difference between statute and common law. Statute law practiced in many countries such as the EU is that things are prohibited unless allowed. They're generally prohibited unless you've sought and gained approval for them. In common law, which is the practice in Australia, the UK, where our laws were transposed from New Zealand, US and Canada, common law allows everything unless it's prohibited. And that's a very considerable difference, and one that is informed by case law. And that's why these court cases are so important, is that they provide a basis for the next decision. People can go back and look at the decisions of the court historically, and they can see what happened, what the evidence was, and what was allowed. Now, this has a very rich heritage, this concept of peaceful enjoyment, where you should be allowed to do what you want to do without interference, was in many ways cemented by the Enclosure Acts in the 1600s in the UK, where for the first time, because people were told that they had to fence their properties, it meant you could grow crops without your neighbour's livestock eating them. That was a very important advancement. It meant that people could grow cereals, vegetables without loss. That was really the start of the agrarian revolution. But underpinning that was this constant ribbon through that it was assumed that impacts could be absorbed within the receiving environment, that the receiving environment was large enough to handle anything that could be thrown at it. That changed when the Industrial Revolution in the UK came about, and there was the first conflicts between factories and farms in terms of air quality, noise, water quality impacts in particular. So they developed these two things: individual assets, individual rights over assets, over your own land, where you could essentially do what you want, and community assets, which are still groundwater, air, receiving water quality, surface water quality downstream. So the courts are incredibly important, not just about the small number of cases that just get litigated, but it's society understanding that they have rights to go to an adjudicator, and that if community assets or your assets are being interfered with, you can go to adjudicate, an independent adjudicator, and you can get a decision made that'll either stop the nuisance, stop the harm, or curtail it. There's a Judge Rackerman in the Queensland Court has quoted this concept of the silent party being represented in court, which is the public interest. I would go one step further and say that the receiving environment is the protection of that is in the public interest too. But that's a very important concept as well, that you have parties in these court cases, but the silent party is one where the public interest is being protected. So with conflicts, they're generally adversarial and expensive. A very important point is that experts who take evidence to court have their evidence deconstructed by barristers. I would say that anything that gets in the way of that deconstruction, where you are being told, you're being asked about the evidence that you've prepared, and you're often told where you're wrong, that's an incredibly important part of the process. And anything that gets in the way of that is a problem. The parties that are being represented by the lawyers that are asking these questions have the right to the answers. In saying that, without the data, there is great theatre, potentially great theatre in that. And when land capability assessment is inadequately accounted for, that's when maybe mistakes can be made. I'll just briefly talk about the literature, but there are really three principal research areas that come together with my thesis. One is land use conflict, one is the land capability assessment themselves, and the other is the treatment of expert evidence in courts. There's limited literature on the problem of courts assessing the epistemic quality of the land capability assessment. I won't dwell on these for long, but in respect of land use conflicts, there's quite a body of literature. The history and development of case law over time has been well documented by Golan. Edwards looked very carefully at the process of stakeholder engagement and the idea of people feeling confident about having their say. Kennedy has recently looked at the privileging of scientific expert evidence and how that makes some stakeholders feel. And she points out that it makes them feel divorced from the process and their evidence having less value. Vallas talks about the need to couple science with ethical values, and again, that's a key issue. With land capability assessment, again, there's a great body of data, and they come together and have improved enormously over the years, but from a very good foundation. Again, I'll run through them very briefly, but Barnett came with the Australian groundwater modelling guidelines. Bennett has talked about the need for structured soil security, and you'll know that there is a very significant loss of topsoil been calculated for a great many agricultural and industrial processes. There's the vulnerability of mass survey techniques looked at by Droop and Matthew. Mapping accuracy, this definition of groundwater mining. Mulvey now looking at agricultural practices and carbon sequestration. And Withers and Vipond early on in the piece, looking at minimum stream flow discharges, not looking at averages, but looking at the minimum. The place and treatment of expert evidence in court has also got a large body of evidence about it. And I'll just touch on a couple of these points here. Edmund has been very critical of this idea of the theatre, the performative quality of expert evidence, where, for example, concurrent evidence and the switch to concurrent evidence may not be based on empirical research. Feigman has talked about the gap between scientists who want to generalize the whole time and lawyers that want to particularize the whole time. Hack has talked about the need for practical guidance to judges. And Perillo has talked about adversarial allegiance. No matter how good the expert is in trying to avoid being an advocate, the statistics show that the person who is paying you gets more allegiance from the expert than the person who doesn't. Hugh Selby talks about the repelling nature of litigation to numerical ratings, and I'd certainly subscribe to that. So it's really been down to the courts in terms of changing their approach to rules and standards and developing them over time to better manage expert evidence. The New South Wales Land and Environment Court's got the joint expert policy. Queensland Land Court's got now court-managed expert evidence, where a registrar or a member in the court oversees the joint meetings between the experts. Now, this year, the Queensland Planning and Environment Court, like the Queensland Land Court, has come out with revised rules and has recognised data sufficiency as being one of the issues where an expert may not be able to give a concluded or a settled opinion. So, bearing all that in mind, what I did was to look at land capability being a function of three things: land quality, land tenure, and water supply. So I sought to identify the critical attributes and data indicators. I constructed a visual hierarchy, and then I derived a method to test and validate an indicant based on that visual hierarchy. And that was really to make the hierarchy accessible. Just briefly run through this for you. Don't expect you to see that. I just want you to know that it's complicated. These are zoom ins, and you can see there that these indicators are developed from land quality, water supply, land tenure. This is where it goes into the science, where we're looking at evaporation deficit or surpluses. We're looking at covenants, regulations, and we're looking at the landform itself. Looking at the sedimentary records, landform elements, slope, soil quality, the variability in rainfall, the irrigation demand, and the split between surface water and groundwater. It then increasingly goes to this analysis of for the landform, the parent material, the regolith depth, whether we have alluvials or colluvials. All of these are very important in terms of land quality, whether they should be protected for agricultural use in the future. And then we descend further into the chemistry and the physical nature of the soils as well. So it's just to illustrate that these are key indicators that we would look to, and that if they're assessed early, then you can underpin any evidence that you're giving based on the science of it. So to evaluate the indicant, I went back to 5 real-world cases between 1999 and 2020 in the jurisdictions of Queensland and New South Wales to objectively compare the assumptions, the information, and the assessments that were made. Then to validate that, I sent out the indicant that was developed with 3 further land use conflicts, different ones, to 4 recognised court experts and to 1 third-year undergraduate student in agricultural science. The idea of including the student was to check on whether or not you had to be an expert to use the indicant. So the cases, and again, very briefly, one was a coal mine, the Bickham coal project, the first coal mine rejected in New South Wales history. The QCLNG pipeline dispute with the contractor, which was a very large dispute putting a gas pipeline from the Surat Basin up to Gladstone, and reputedly one of the largest commercial disputes in Australian history. Then Hume versus Patterson was a case where a boy got catastrophically injured in the Tweed River wake skating, and the evidence in that case was about the movement of a sandbar and the geomorphology of the sandbar and the way the water moved over and relative to the sandbar. Fourth case was a landholder rezoning compensation claim based on whether the land was good quality agricultural land or not. And the last case was a case in Mowra, Queensland, where a farmer disputed with an energy company that his land had been restored once the underground pipeline had been put in. For the validation methods, these were the ones that went out to the external experts and the student. Another landholder rezoning compensation claim, keenly fought. The amount asked for compensation was $45 million. The next one was a groundwater commercial water abstraction on Mount Tamborine in Queensland, where Coca-Cola were bottling groundwater. And the last one was a large set of chicken farms at Manila, where the neighbouring landholder was disputing whether that should be allowed. Now, the experts that it was sent out to were comprised of an expert civil engineer who has done tens of cases. There were two other hydrogeologists, one a hydrogeologist as well as being a soil scientist and a contaminated land auditor, and the other was the agricultural student. A huge variety of expertise, and that came out actually during the running of the Indicant. So the Indicant is a web-based recorded survey with the questions based on the court process and complying with the court rules. The critical indicator hierarchy that I've shown you, and then it goes through branch logic through the specific areas of expertise that the experts themselves have chosen. And it also looks to questions of data sufficiency. If you answer the questions in particular ways, you are marked up and down. And for example, if you're looking at soil erosion, yet you haven't looked at slope length, gradient and dispersivity, you get marked down with the Indicant. If you've collected that data, you get marked up. So what this means is if you're looking at two sets of opposing experts, you can rank the data. The other point is that the Indicant is open access. This is an example. I've just got a few shots here of the Indicant, the way it looks on the mobile telephone. And you can see that there's a series of questions where it's really a multiple choice exercise where you can record your name, you can record the name of the case or the number, and you can say what jurisdiction you're looking at. Then you go through the court rules themselves, and these are very specific questions about you being sure that you've got enough information to actually go to court. And this is a ready reckoner to allow experts to check their own briefing material, their own knowledge of the issues in disputes, and whether they've actually been to the site. The areas that the Indicant is currently set up for are up on the board here, but really related to the areas of land, water, groundwater assessment, and contamination. Here's just an example of the minimum number of observations for the survey, and was the survey fit for purpose? And this goes to the idea of data sufficiency and checking that you have met the minimum requirements really to assist the court. And at the end of the day, you get a score, or the evidence that you have looked at is scored, and then those scores can be compared. Now, I will very briefly go out to the results, but the headlines are these. For all 8 land use conflicts, there were shortfalls in all of the data sets for all of the participating parties. So whether they were applicants or submitters or respondents or defendants, everybody had shortfalls in the data sets against the critical indicators. The difference is the key here, and you'll see there that there is a difference. What this table's showing you is the difference between, in the first one, the submitter at 516 has scored higher than the applicant at 296. But you'll see the range is minus 950 to 850. And that's repeated on the way through. When you move to the validation cases, you can see that there's quite a spread in terms of each of the validators. So the first 5 validators in that table are the external validators. Sorry, it may be that somebody has their microphone on online. We've just got a little bit of interference. But you'll see that there's quite a difference there in terms of the way they were assessed. Now, this is to be expected because the validators were given free rein to select the areas of expertise that they felt comfortable in commentating on. And that was very important that they were given that freedom, because sometimes in court cases, you'll have people absolutely matched in their skills and experience, but other times there's overlap. So statistical analysis was completed qualitatively through a user engagement survey of the validators after they used it, and then quantitatively using descriptive statistics and Kendall's coefficient of concordance. So that was the degree of agreement. The thematic analysis of the interview data of the validators after the event was really useful, and they came back with 3 themes: the definition of the participatory role in the process, the importance of the brief, and the use of the confining questions. Just quote a couple of responses that I've got and detail in the thesis. But there was a couple of responses here. It was difficult to reference my reliance on the counterparts, the opposing experts' work. Regolith wasn't mentioned in the materials. I had to spend a lot of time looking at it. So in respect of the brief, and this is something that is a common theme with experts, you find that brief, the initial brief, has to be very, very clear. But then the last one, in terms of the use of confining questions, the questions were stark. It was hard to express the differentiation of the parties. There is no need to change the questions, and the questions make perfect sense. So those responses went forward and allowed for the change for the second iteration of the indicant. The descriptive statistics, you can see that there's significant variation in the responses between the validators. And in terms of the Kendall's coefficient of concordance, this was the basis of the degree of agreement, whether it was strong, good, or so one of the areas, there are 12 areas of areas of expertise and areas of study that people are looking for. I'm sorry about this interference. There's nothing. Is it feedback?
Yes.
Speakers in this room. Apologies online for the team. Quite turns ground here. Now, no one can hear. Professor, thank you very much. Thank you. So look, very briefly, I've just picked out one table here, which shows fair to weak agreement in the coefficient of concordance, which is the W. And you'd expect that in terms of there's such a variety of materials, and also with the validators, there was this variety of experience and expertise. Significantly though, when the overall score was generated, we had this very strong agreement between all of the experts and also the agricultural student too, that looked at each of the cases. Now, that was important in itself, in that all of their judgments were exactly the same as the judge or the adjudicators in the original case. So within the individual subject areas, the validation results were not statistically significant. But in terms of the overall ranking of the evidence, viewed in its entirety, those answers gave a significant statistical difference amongst the ranked scores. Now, I'm not making any claims about the individual scores themselves because of the variability and all those factors I've said, but the rankings came back the same. So the corollary of that is that all users came to the same outcome, irrespective of their areas of expertise and degree of expertise. That this shows that the indicant dominates the assessment, not the assessor. That is a key outcome. So if using the indicant gives the same result as the judges or the adjudicators in the court case, you may say, what's the point? The point is that if this happens earlier on, before these cases are ventilated in the courtroom, happens during the joint expert process, there's a chance then, excuse me, of saving time and money. And that's really the objective of this. So it's the early recognition of issues too that will save time and cost. Now, if we have time, I just want to run through, it's really going to these real world problems and the increasing degree of conflict and issues that we're seeing, not only in the competition for community resources, community assets, but also as a result of the variability in the climate as well. This is the main road outside our farm in Talgum. It's going to be cut for 18 months after the February floods. This is a landslip on the on our property where the creek went up so far it eroded the toe of the hill. Now, bear in mind that these slopes have been cleared since the late 1800s, so 1888, and you can see that that had pretty much full vegetative cover there. There had been some slippage there earlier, and I fenced the area off. You can see that. But it was the degree of this event. Here's a picture of my youngest son here, where this is about a 4-acre slump that occurred after that. You can see the degree of root ramification there. 100% vegetative cover again, but this unusual set of events in terms of rain since November, and then this massive event in February where it was close to 1,200 millimeters over 3 days. This is down just at the front of the property on the Oxley River, where Billy and our neighbour are standing there. That slope has been eroded out. You can see the sandstone basement is very clean, and the whole area is eroded out, causing the landslip there. So, conclusion from the thesis. This is just a first step in providing the courts with courts or adjudicators or stakeholders with a scientifically based indicant that looks at the critical indicators and attributes. It then went to take that indicant that was developed from the hierarchy to objectively compare five cases and to see whether we could rank the evidence. The evidence was able to be ranked. Then it was sent out to people to test and validate the indicant for people who are recognised court experts and the student. So the research has shown the indicant using critical assumptions and attributes can objectively test the assumptions, the data, underpinning expert evidence. Comparisons may be usefully ranked. The ranking can be used by others with limited expertise, and that the indicant could decrease time involved in court assessments of expert opinions. I just wanted to then acknowledge my panel. Dr. Sarah Beavis has just been wonderful to deal with, the chair of my panel, so thank you, Sarah. Professor Ian White is an old friend of mine, and I'm very grateful for all of his input over the years in this endeavour. And Phil Matthew, I couldn't wish for a better friend. I'd like to thank the Fenner School, if I may, publicly. You have been great support, and also the ANU too. I'd like to thank my colleagues who've been involved in assisting me and giving me advice. I'd like to thank the validators who I've kept their names private in the thesis, but Trevor, Eric, Bill, Mark, and David, you know who you are, so thank you. I'd like to thank my friends and family. Our farm wouldn't, and our business wouldn't run without great support from my family, whom I value very much, and my dear wife Suzanne. These are the conclusions proper, which these are the contributions that I'd like to leave you with. And this is what I would like the thesis to be used for, to better understanding of these interactions, an increased awareness of data quality during litigation, helping counsel, the barristers and the lawyers, understand where the evidentiary pinch points are in their cases, because they're the ones telling the story to try and win their cases. Reduced emphasis on the theatre of court presentations. Equipping stakeholders, they can use the Indicant, and lower costs would save time. I should have said that the Indicant, the validators were able to use the indicators generally in around the 15-minute mark. It's not a big exercise to use this Indicant. 45 minutes, it took the student 45 minutes, but he was very diligent. So if you're still with us, I salute you for going this far. Thank you for attending today, and I will welcome any questions. Sir.
Hi Neil. So I grew up on farms in northern New South Wales. I've worked on a few farms in Scotland. They're trying to do a PhD with grey hair, so I've got lots of
We have a lot in common.
So I'm sort of curious. It's a bit of a traditional approach, and you know we're in agricultural 4.0 that is really highly reliant on big data and utilising that data for better decision making. And we see that on farm, through value chains, into global markets to make these things form more efficiently. But I sort of didn't hear that the courts and the litigation process and the utilisation of experts are really up with that. And you know, your second point there is about this awareness of data quality. Like the capability we have now in using big data in agriculture for better decisions is immense and really helpful for resolving lots of the big problems, making things work more efficiently, align policy, blah, blah, blah. But in this, we've sort of taken it from the UK a long time ago, and it's like we've shut our eyes in agriculture to what real good quality data and big data can do. And we're sort of still relying on these experts, no matter how validated they are. When will the courts utilise, you know, agriculture 4.0, not agriculture 1.0?
Well, that's a great question, and hopefully that was heard. But the summary is this: when will the courts utilise the massive data capability that's now available from satellites, from testing, rather than just relying on individual experts and the testing that happens side by side? So it's a great point, but I think the key goes back to what the litigation's generally about. The litigation generally is about a proposed land use on a site, and the people will argue black and blue that their site is maybe different to the neighbour's site. It may be that, and they have a right to do that too. This is where the courts are also very important to ventilate those opinions. There is an issue, I think, in terms of big data, which is showing that agricultural impacts are far greater than you and I were probably brought up to believe. So, for example, as a broad statement, the truth of the matter is that if I can irrigate land, I can increase the productivity by a factor of 10. If I apply fertilizer, I can generally increase the size of my farm by 3. The problem, though, is that you and I were taught that we'll be able to use 75% of our additional nutrients that we put on and make them available for plants. We'll lose 25% through deep percolation. Unfortunately, it appears as though it's the other way around, that we lose 75% of the receiving environment and only use 25% of it. So on the one hand, you've got the rights of the litigants to focus absolutely on the sites in question and the projects in question. And that's where it will always be focused. That the court won't necessarily want to hear about regional policies. It may do, and there's certainly in terms of agricultural land protection, the courts will place regional policies quite highly. But in terms of these offsite impacts and the impacts of agriculture that are really happening, that's where big agriculture is vulnerable and the data is very useful. And I probably see that conflict, that's a worrying conflict that will start to increase. And I'd suggest that that's probably where you're going to see the big data. You're already seeing it in terms of reef protection in far north Queensland, where big data is influencing the land use policy. I think that's probably the best answer I can give.
Thank you.
Thank you. Yes.
From the internet.
Okay.
Did your research detect an opportunity to broaden the areas of research did your research detect an opportunity to broaden the areas of expertise / issues in dispute to other fields?
So if you didn't hear that online, did the research look at the opportunities to broaden this into other areas of expertise? So the research that I've completed only looked at land assessment, land capability, the agricultural side and water resources. But yes, it's a method. This research demonstrates that there's a method there which makes this accessible, and I would see no reason why it couldn't be, that hierarchy couldn't be expanded into areas of odour, noise, ecology, other areas, providing these criteria are set. I'm not saying that the criteria are all right. I'm not making the claim that everyone is right. I'm saying that they are there. They're established criteria that can be referenced. They're repeatable and they're measurable. So it provides a rule base. That rule base can change over time, but it's an initial first step rule base with a hierarchy. So yes, it could be expanded. Professor.
I was wondering, Neil, it was the validation was based on 5 users across 4 projects, I think.
Yes.
So is that enough evidence for a court to accept that process? In other words, do you think that's enough validation?
I do, for this reason. So it was three projects and 6 users in total. So me as well as 5 other users. What this would do in the process is allow for a focus on the issues in dispute. So when you are put into a joint experts process, you're asked to list your areas of agreement and disagreement. The questions in the indicant are stark to really focus the expert in and make sure that they understand that this data needs to be collected. I say that those were broad disputes. They also lined up with the results from the 5 other evaluation disputes. And in themselves, they were a very broad array of disputes too, from pipelines to the injury of the creek. The commonality, though, is very much one side tends to have data and the other side is often saying, in the absence of data, oh no, that data's wrong. My proposition is that if you don't have your own data, then you have to accept your counterpart's data if you've got no valid reason for saying it's wrong. That's a sniping approach, which I don't think is of help to the courts. it has to be a constructive approach. I have to be able to tell the barrister who's cross-examining me why I think it's wrong and what the basis is. So straight answer to your question, I think it's enough as a first step. And I think as people use it and have access to it, then it'll be something that people get used to.
We have another question.
Yes.
Can you explain how land courts operate in different jurisdictions across Australia? And could this affect an epistemic approach while in Australia?
Well, thank you. So I'll just repeat the question again, just in case you didn't hear it. Can you explain how different land courts operate in different jurisdictions? And could this affect the epistemic approach, Australia being so large? There are differences between jurisdictions, and the rules are different between jurisdictions, and the processes are different between jurisdictions. I say, though, that these critical indicators and attributes are common, and they're common across all jurisdictions, and they are common to all landforms in different degrees. The basis, though, I say, is the same. It's more this method that have you got enough data? So do you have 4 groundwater bores where you can look at flow direction? Do you know what the depth to the regolith is? Do you know what the depth to the basement is? These are basic questions that are important in Oman. They're important in Cape York. They're important in Tasmania. So I would say that the rules are pretty specific. In every jurisdiction that I've given evidence in, the rules have been clear, but I've had that commonality within the science. I hope that answers your question.